Constitution a suicide pact? Are AR-15s suitable for self-defense? Should you be able to ban guns just as easily as you can ban fentanyl, and for the same reason? These and many other stupid arguments against gun rights are covered in the brief we just filed before the First Circuit Court of Appeals in our lawsuit challenging the Massachusetts so-called assault weapons ban. So, I'm going to go over a lot of those arguments in detail and what we're telling the court, and kind of the answers to a lot of those stupid arguments. But before we get there, I want to set it up a little bit just by way of refresher for those of you who may be new to the channel. We filed this lawsuit about 1.5 years ago, shortly after the Bruen ruling was issued. It's a lawsuit against the Massachusetts assault weapons ban and magazine ban that was signed into law by Republican then-Governor Mitt Romney. Which is a reminder, as always, that just because they're a Republican does not mean they're pro-gun. And nowhere is that more true than in the case of Mitt Romney. So, we had our oral arguments at the district court. The district court judge, as we will discuss in more detail here in a minute, is rabidly anti-gun and ruled against us naturally. So we appealed to the First Circuit Court of Appeals. The First Circuit Court of Appeals is not necessarily what you would call a gun-friendly court. Of the 10 judges on the First Circuit, 8 of them were appointed by Democrat presidents, including Chief Judge David Barron, who, by the way, is a former Harvard Law School professor. During his time at Harvard, he wrote the Obama White House a memo authorizing the use of drone strikes to execute U.S. citizens without a trial.
Want to go to lunch, Private Bluth?
Not till I take you out the hospital! You're not gonna get away from me, little nurse. Take that, Taliban wedding!
You just took out an art museum in Madrid. You could have hurt some innocent people.
Innocent people?
When President Obama appointed him to the First Circuit Court of Appeals afterwards, U.S. Senator Rand Paul strongly opposed that nomination, saying this.
Senator from Kentucky.
I rise today in opposition to the killing of American citizens without trials. I rise today to oppose the nomination of anyone who would argue that the president has the power to kill an American citizen not involved in combat and without a trial. I rise today to say that there is no legal precedent for killing American citizens not involved in combat, and that any nominee who rubber stamps and grants such power to a president is not worthy of being placed one step away from the Supreme Court. Where has candidate Obama gone? President Obama now puts forward David Barron, whose memos justify killing Americans without a trial. Now, I can't tell you what he wrote in the memos. The president forbids it. I can tell you what Barron did not write. He did not write or cite any legal case to justify killing an American without a trial, because no such legal precedent exists. It has never been adjudicated. No court has ever looked at this. There has been no public debate because it has been held secret from the American people.
Senator Paul is 100% correct about that, and it is very, very concerning that someone with as little regard for the Bill of Rights as Judge Barron is now on the First Circuit Court of Appeals, which our lawsuit against Massachusetts' so-called assault weapons ban is now before. So I emphasize that to say that we're not going before a gun-friendly court, and we will not be surprised if that court then rules against us. In that case, we will simply appeal to the Supreme Court, and that's kind of been the plan all along. So with that said, let's get into where we're at today. So with an appeal to the First Circuit, the first step is to file your opening brief. That's basically all the legal arguments you're setting out for why the district court got it wrong and why the appellate court should rule in your favor. So I kind of want to go over a few of those highlights with you. Now, our lawyer, Barry Arrington, who's an extraordinary Second Amendment rights attorney, he starts every major brief in a gun ban case, like this one, in the same way. This is a simple case. In New York State Rifle and Pistol Association versus Bruen, the court set forth a two-part test for reviewing Second Amendment challenges. 1, is the plaintiff's proposed conduct covered by the plain text? 2, if so, can the government demonstrate that its law is consistent with the nation's history and tradition of firearms regulation? In this case, we can easily meet step 1 because the banned weapons are bearable arms, and their desire to keep and bear them is covered by the plain text. But it is impossible for the Commonwealth to carry its burden under Step 2. Tens of millions of the banned weapons are possessed by law-abiding citizens for lawful purposes. In D.C. v. Heller, the court held that there is no tradition of banning weapons in common use. Therefore, the statutes are categorically unconstitutional. In summary, millions of citizens own tens of millions of the banned weapons. Under the Supreme Court's precedents, that is all that is needed for citizens to have a right under the Second Amendment to keep such weapons. That right there is a beautiful summary of our entire case. The Second Amendment protects weapons that are in common use, and it doesn't get more common than AR and AK platform rifles for self-defense and for other lawful purposes as well. You cannot ban these guns. And this is very simple, right? It's only when courts and leftist attorneys start trying to get around the plain text of the Supreme Court's precedents and of the Second Amendment itself that things start getting really, really complicated. But they're not complicated if you're willing to actually apply the words of the framers and of the Supreme Court's precedents. And so we start every brief by emphasizing that. And so we then go on to explain how the Bruen test, which is based entirely on the text first and then the history and tradition of the Second Amendment, completely obliterates the Massachusetts gun ban. And I want to read you a brilliant section right here that basically captures this in a nutshell. Defendant insists that it is constitutional to ban 99.998% of assault weapons that were not used in homicides because of the 0.002% that were. Defendant is wrong. Millions of citizens own tens of millions of AR-15s, and they use them overwhelmingly for lawful purposes. Under the Supreme Court's precedents, particularly Heller, that is all that is needed for citizens to have a right under the Second Amendment to keep such weapons. The same is true for banned magazines. There are over 150 million such magazines in circulation, and that is all that is needed for the magazines to be protected. So after we lay all of that out and explain how essentially we've won our case under both Heller and Bruen, then we start tackling the district court's ruling. Particularly this one section from oral arguments where the judge said this: "It seems to me bizarre to say that all you need to show is that lots of people have these weapons. I mean, lots of people have fentanyl. Millions of people probably, have illegal drugs. That's not the standard for whether or not you can ban it." So there you have it. This district court judge actually thinks guns are on the same level as fentanyl and should be able to be banned for the same reason. And there's more, it gets worse. He actually said, referring to the Heller common use test, "As long as it becomes commonly used, we're stuck. The Constitution is, in effect, a suicide pact." So there you have it. That's what these leftist judges actually think about all of us. They think law-abiding gun owners are basically crackheads. So yeah, that's a very encouraging thing to hear from the federal judiciary. Now, of course, we answer that. We point out that that's a ridiculously outrageous thing to say. And we also point out that the court made its way back to stealth interest balancing, right? Where they found another way to kind of work in that cost-benefit analysis, say the Second Amendment's too dangerous to actually enforce properly. That's the very thing Bruen said you can't do. And they found a way to make it happen anyway. And we point that out here. The district court performed this feat of jurisprudential alchemy by first noting that Heller held that banning dangerous and unusual weapons is consistent with the nation's historical tradition of firearms regulation. And then the court held that this test means the government may ban weapons that are unreasonably dangerous and unusual in the sense that they are not suitable for self-defense, and therefore not reasonably necessary for self-defense. Now that's some judicial gymnastics right there. I've never heard it referred to as jurisprudential alchemy, but that's exactly what this is. It's where you're taking what the Supreme Court said and twisting it to mean essentially whatever that you want it to mean. So dangerous and unusual, as Justice Alito has pointed out before, that's a conjunctive test. It's dangerous and unusual, which means that if a weapon is in common use, it by definition cannot be dangerous and unusual, and so you can't ban them. So what they're trying to do is separate those words, dangerous and unusual, and twist it into unreasonably dangerous. Well, now that makes it basically a matter of opinion. And so in the court's opinion, AR-15s and AK platform rifles can then be banned. That's why it's essentially magic. what's happening here. This is legal magic, and it is not the way to enforce the Second Amendment, and that's what we're telling the First Circuit. There's one more thing really quick that I want to hit on, and that's the fact that if you want to look at history and tradition of the Second Amendment, look no further than the early militia laws. Not only did the founders not ban guns, they actually mandated guns. Not only did they not limit your magazine capacity or your firing capacity, because they didn't have magazines at that time, they actually had a minimum required amount of firing capacity. And we point that out here. During the founding era, both the federal and state governments enacted laws for the formation and maintenance of citizen militias. These laws did not ban firearms or restrict firing capacity. They did just the opposite. By mandating the acquisition of firearms and a minimum firing capacity, i.e., the laws required citizens to arm themselves with a minimum quantity of bullets and gunpowder. It follows that far from being analogous to a founding era law, the statutes would have been unthinkable under the understanding of the Second Amendment at the time of the founding. So there you have it. There's no way, both under the text of the Second Amendment and under its history and tradition, that the Massachusetts gun ban should be upheld. Now, whether or not the First Circuit will see it that way is yet to be determined. As I said earlier, don't be discouraged if they say no. We are prepared to appeal. That's been the plan all along. So we are going to continue fighting. But right now, we just filed this opening brief. The next step is for Massachusetts to come back and respond to that. And we are requesting oral argument before the First Circuit in this case. So hopefully that will be granted, and we will let you know when we have a hearing date. So thanks so much for listening. If you'd like to get involved and help us fight to end gun bans in the federal courts, we have a number of lawsuits everywhere, one of which we've already appealed to the Supreme Court. So we need your help in this fight. And if you'd like to get involved with that, there is a link in both the description and in the comments below where you can contribute to our legal war chest. Once again, thanks so much. We'll see you next time.